Hey, Paul here again, and in this video we're going to talk about whether a photocopy of an original last will and testament is valid. Okay, so sometimes people die and the survivors, for one reason or another, I'll get into a few of those reasons, the survivors can't locate that original will and they want to know if a photocopy is sufficient. So let me get some definitions straight. By original will, I typically mean it's that one that's the one that was actually signed, may have been notarized and embossed, and so you can feel the notary seal perhaps on the last page. It may have been signed in blue ink, so you can tell it's the original, although, you know, photocopy machines are pretty good now on the blue ink stuff. So people want to know, hey, we can't find the original. Is this photocopy, you know, sufficient to be used to transfer my mother, my father's things? So let me give an example. So common example, let's call him Mr. Will Writer. He writes his will when he's 65 years old. And, you know, when he writes it, the lawyer gives it to him and he keeps it in his important papers. He lives for many, many more years and he dies when he's 90. Now, when he wrote that will when he was 65, he left everything to 3 of his 4 children in 3 equal portions. He excluded his daughter, let's call her Darla, and he named his son Ed as the executor. And he died with it when he was 90, 25 years after he originally wrote the will. So now he died. Nobody can find the original will. Sure, he left a copy with his attorney. He left a copy with his executor, Ed. He may have even left a copy with his daughter, Darla, he excluded. And so, but they just can't find that original. It had been 25 years since he signed it. What happens? Well, our Louisiana Supreme Court, as is the case in many other states, most of the other states that I looked at had the same rule. And it says when a will, or when that original will, cannot be found at the testator's death, there arises a presumption that the testator has destroyed the will with the intent to revoke it. Now, that presumption that the will was destroyed with the intent to revoke it can be rebutted by clear proof of, among other things, if it's proven that the will was not revoked by the testator. That's a tough thing to do. How do you prove that somebody didn't revoke their will? It's that old proving the negative thing, which is really difficult. So going back and looking at our circumstances where Mr. Will Writer died 25 years after he wrote the will, he left his estate, let's call it a $2 million estate, to 3 of his 4 children. And his daughter Darla was excluded. He dies. Everybody's producing all these copies of his will, but nobody can find the original. Well, our law says the presumption is he destroyed it with the intent to revoke it. And since that's the presumption, and if he revoked it, you go back to the intestate laws that would apply if he didn't have a will, which means that Darla gets $500,000. She gets 1/4 of that $2 million estate. Because if he didn't have a will, then things would be divided equally among his 4 children. Okay, so I've got some issues with that, because what I've found over the years and in my gut is that when somebody dies and there's copies of the will that can be produced by people that are close to the testator, but they can't seem to put their hands on the original, my gut is not that the person destroyed the will, the original, with the intent to revoke. My gut is that it was just lost. And so, you know, because several things can happen. In our example with Darla, who was excluded, now maybe Mr. Will Writer's will was lost because he moved several times from when he wrote the will from age 65 to 90. Maybe he, you know, had some demented or cognitive, you know, abilities or inabilities that caused him to misplace or lose the will. Or maybe, I hate to think this about people, maybe either before Mr. Will Writer died or maybe shortly right after Mr. Will Writer died, Darla went in and plucked that original will out, and which was a $500,000 pluck for Darla. Because again, since nobody can find the original, it's presumed that he destroyed it with the intent to revoke it. But I think in most cases when that original can't be located, because it's been years, if not decades, since it was originally signed, I think in most of the cases that original was lost. What I also find is that when people who have gone to a lawyer and have written wills, and then their circumstances warrant them changing or redoing things, they typically don't, destroy their will with the intent to revoke it. They typically go back to the lawyer or a lawyer and they write a new will, or they change their will. But typically you don't find people when they say, you know what, my circumstances have changed. I know I did this in my old will. They don't just destroy the old will because they want to go back to the intestate laws. They actually go to a lawyer and do either a codicil or a new will to fix whatever needs fixing. So to make the presumption, and that's a pretty stiff thing, to make the presumption when the original can't be located after death that they destroyed it with the intent to revoke it, that puts a tremendous burden on those people that are named in the copy of the will to have to prove that he didn't revoke it. Tough thing to do. Now, we don't see that with trusts. Many people, instead of going kind of the customary traditional last will and testament to provide for the disposition of their things, they often set up their revocable living trust, name a trustee, transfer assets to their trust to avoid all the probate stuff. Not a problem when you can't produce the original trust when someone passes away. Assets are transferred at financial institutions and at other third parties all the time by using a photocopy of a trust. So you don't really read or hear about one of the advantages of using a trust to dispose of your assets is that you don't have to have the original trust when somebody dies, when you do have to have the original last will and testament when someone's leaving their assets to their heirs through their will. So, but as we go back and look at it, in the absence of that original will, should, in our circumstances where Mr. Will Writer had written his will 25 years earlier and left things to 3 of his 4 children equally, his $2 million estate, and he excluded his daughter Darla, when he dies and that original will can't be located, but there's copies everywhere, should Darla have the burden of proving that his will was revoked? Maybe so. Or should the 3 kids named in the copy of the will have the burden of proving that it wasn't revoked? Tough thing to do. So that's the question here. Love to hear your thoughts. I would say a couple of issues here just that are related in our procedural rules. So I will tell you, and I've dealt with this issue a number of times, we have a rule that says if a person has possession of a document purporting to be the testament of a deceased person, even though he believes that the document is not the valid testament of the deceased or has doubts concerning the validity of thereof, he shall present it to the court with his petition, praying that the document. So if somebody's in possession of something that's purported to be a will, so what that says to me is if someone does have a copy, they've got to file it into the record, but a judge may not follow it because that presumption may not be able to be rebutted. A couple of other issues. Somebody might say, well, surely when somebody gets divorced, they're going to destroy their will and revoke it. But we have a provision that says if someone does write a will and then gets divorced, yes, that bequest to that spouse or that former spouse is revoked, but the rest of the will remains valid. So it may not be necessary for someone to just destroy their will after they get divorced. But bottom line here is, people are writing wills all day, every day. I'm sure there's hundreds, if not thousands of wills written across America. The really key is, keep that original in a secure place. I've made some videos. You can read and watch lots about where to keep that original will. Make sure that the right people have access to it when you pass away, and maybe just as important, make sure that the wrong people don't have access to it when you pass away, because just like I mentioned, when Darla was excluded by her father in the will, if she just plucked that original will out of his records, now the presumption is he died intestate, she gets 1/4 of the estate, and at a minimum, there's going to be a court battle between those kids when the other 3 try to rebut that presumption that he destroyed his will with the intent to revoke it. So, so there you have it. Boy, keeping the original will, really, really important. And the problem is it doesn't get produced until after the will writer or testator dies. So now you're relying on, several people to have to produce those documents. Okay, hope that helps. I'm Paul Rabalais. Y'all have a great day.